Welcome back to Psychology Applied to Work. This is lecture 13, Hiring Decisions. All right, lecture 12, as you recall, was a bonus lecture, and we covered individual differences at work. And we covered what those dimensions were. Specifically, we dove into personality for a while. We talked about cognitive styles. We talked about life experiences, and we talked about neurodiversity. This lecture 13 today, this begins chapter 5, and we're going to talk about hiring decisions for selection, and we're going to talk about the overall employee selection process. We're going to talk about determining selection cutoffs. We're going to talk about hiring, employment, and the law. We're going to talk about legal exceptions to protected class and legal theories of discrimination. So let's get going. Now, briefly, for chapter 5, if you haven't already looked, it's a nice short chapter. It's only like 11 or 12 pages. So, and the 3 lectures for this chapter will be on hiring, recruiting, and retention. And retention will be the bonus lecture. Retention is barely covered in the book, and it's definitely a worthy topic. I've gone over the typical 50-minute time frame for a normal 3-credit class on a number of occasions, and so as long as I don't see any squirrels to chase, I am going to try to make up for some of this time for this week's lectures, because it is corresponding to such a bite-sized chapter. All right. Now, first thing, employee selection process. If you're going to have, you need to have a process in an organization, and you want it to be objectively defined, and you definitely want to follow all employment laws, and we will get into what those are in the second half of the lecture. And you should make sure that your positions are defined and that they're mapped to job analysis. At this point, that should be familiar to you. Really, the job analysis part is, you should look at job analysis as the first step to building your selection process, or the first step of your selection process. You definitely want to have a job description with your required qualifications. You'll want to know what tests you're going to be used to measure the KSAOs that are needed. You're going to want to follow that process for recruiting. So the overall selection process, you'll have a recruiting process, you'll have a filtering process, you'll have an interview process, those sorts of things. You'll want to use your tests fairly and consistently. When you do your interviewing, you'll want to follow a structured interview and follow a defined interview process. Definitely avoid unstructured interview, and then make your hiring decision based on the testing and the interview scores. Pretty straightforward. All right, selection cutoffs. First of all, what we're talking about here is when you have a certain number of applicants, how do you start the first process? Who do you filter out, and how do you establish those cutoffs? So if you have a test, which can be the form of a skill assessment, an experience review, or literally, some sort of knowledge test, depending upon what the position is. You want to make sure your method is valid, and that you establish a minimum cutoff score that you need for job success, and that should be pretty clear as we go here. And then you want to look at a thing called the selection ratio. And really that's if what is the number of applicants that meet that cutoff? And then you want to, we'll talk later about looking at that selection ratio in terms of the different types of people. You'll want to make sure that you're treating people fairly and equally. And so that the ratio of people that don't meet that score, is really just based upon their qualifications and not on other characteristics. So your cutoff score, you can adjust that to get your desired, to set that desired ratio. And here we're talking about, like, if you had 50 people apply for the position and you want to only interview 10, You want to have means of assessing people that 80% of 40 out of 50 of those applicants can be weeded out through cutoff scores for selection criteria before you get to the interview, because interviewing 50 people is a very time and money consuming event. So you want to think about these things, and a lot of factors play into here, which is how marketable is your opening. Are you going to be actually hit with lots and lots of applicants, or are you in a really tight labor market for your particular opening, in which case you can't be so selective. So looking at what your cutoff score is not simply based upon a cut and dry, clearly only mapped to the job analysis. It's also factoring in how easy or hard is it for you to recruit qualified candidates. Will you be overwhelmed with lots of qualified, in which case you're trying to figure out who's most qualified, or are you just going to be grateful that anybody qualified applies, and everything in between. So these things aren't in a vacuum, but cutoff score and selection ratio are important concepts. And you can look at lowering that cutoff score if you want to increase your number of applicants, and that of course dilutes your total applicants, and your overall quality of, so to speak, your overall level of qualified applicants goes down, and that should make sense. And again, it depends upon what your labor market is that you're posting your position within. And you'll want to use multiple tests, multiple ways of selecting people to increase your likelihood of finding the most qualified. And you can take, if you have various assessments, and again, the word test in this case, it isn't necessarily give them a multiple choice test and there's only one right answer. Tests include lots of things that you're doing to assess people. And that can include things as simple as how many years of experience do you have. You don't necessarily think of that as a test, but there's lots of things that are under this term test. So you'll want to have a number of them if you want to increase your chances of getting the most qualified person. So one way you can do it is have everybody take these assessments roughly at the same time or in the same sort of phase, and that's called a compensatory approach. So you have more than one test, roughly around the same time, but each assessment might be weighed differently. The desired versus required. Maybe having 5 years of experience in a particular area is really good, but having 8 years of experience in a nearby technical domain is almost as good. I mean, the way in which you weight them can be complicated and very context dependent. But if everybody's taking this in one phase, all of the assessments, and then you have a different weighting scheme to do your filtering, that's called the compensatory approach. Or you can set it up as kind of a stage gate. You can set it up as a series of cutoffs where each time you're filtering through more people. So you start with maybe 100 people applied online, and you're going to do an assessment, and it might even be automated to get that 100 down to 40. Or whatever, and then that 40 will go through another set of tests to get them down to 20, and then the remaining 20 might take you might take more time with them. You might have more human eyeballs looking at the information they're providing, and then that third assessment level or test level, you might want to bring that down to just 5, and then the rest to be interviewed. But anyway, you get the idea. Is a sequence of filters. And that is called the multiple hurdle approach as opposed to the compensatory approach. More than one. So the multiple hurdle is more than one test, but you give them in a prescribed order. With each test has a different defined cutoff, and that everybody that eventually gets through to the interview, and the interview is its own form of test, that there's a reduction in candidates typically. And an improvement at each level, at each phase, an improvement in the amount of qualified people and the degree to which your candidates are qualified. So hopefully that makes sense. Important things on this slide are bolded. All right. Let's get into hiring, employment, and law. Federal law, that prohibits making decisions about hiring people on certain characteristics, and those characteristics are called protected classes. And we're going to go through a few of the key federal acts. Those are the bills that were signed into law that are relevant here. And the first one is the Civil Rights Act and Title VII. And that was originally 1964 and then modified in 1991. And here, protected class is defined as race, sex, religion, color, and national origin. This is something that is, even if you might not know this by what year the act was passed, this is something that most Americans are pretty familiar with and understand, at least at some level, that these things are prohibited by federal law, and that you can also, besides find yourself in violation of federal law and have your organization fined, you can also be sued by applicants who are saying that you didn't hire them or didn't promote them or whatever because of protected class status and not because of actual job performance or KSAOs relevant to the position. So also in 2020, the Supreme Court of the United States added sexual orientation and transgender status for these protected classes. In 1967, the ADEA, the Age Discrimination in Employment Act, was passed, and that added a protected class in discrimination law for people older than 40. And so that most organizations under the law cannot impose a mandatory retirement age. It's most. There are some exceptions. We'll talk very briefly about some of those exceptions. And then in 1990, the ADA was passed. That's the Americans with Disabilities Act. And that added people with disabilities to the list of protected classes. And disability, the legal definition in the Act, is a condition that interferes with the ability to complete major life activities. And one of the things in the Act is an organization can't inquire as to somebody's disability status if it isn't. I mean, some disabilities are clearly evident, and some disabilities don't manifest in ways that you can clearly tell, and it is against federal law for an organization to basically force somebody to say whether they have a disability or not. Where the law comes into where you run afoul to the law is often when somebody with a disability is unable to reasonably do their job, and that you fail as an organization to provide reasonable accommodation for that disability. And we'll talk a little bit more about that. All right, a little bit more on hiring, employment, and the law. So this isn't just hiring. So there's a lot of employment decisions beyond hiring that are subject to these laws. And so protected class status typically can't be used on the basis of lots of employment-related decisions, and we'll go through the most prominent ones. So hiring, obviously, that's where this whole lecture is focused, but there's all other employment decisions that are relevant to the law. So training and development, it is illegal to choose to invest in the training and development of one employee and not another on the basis of a protected class status. You have to have a reasonable business decision of why one person gets training and not another, and it can't at all be related to protected class. Similarly, performance appraisal. This affects how much money people make, what kind of raise they get. This affects their career trajectory, whether they're likely or not to get promoted, and those sorts of things. So like hiring, these things affect people's lives at a financial level, and so these laws also apply. Similarly, besides obviously hiring, same goes with firing. You can't lay somebody off if there's an economic downturn or fire somebody based on their protected class. the way in which you can't basically designate what type of an employee somebody is. And this can be, something as simple as wage versus salary, but there's other ways of doing employee classification. We won't get into it, but it's another thing that can't be used based on protected class status. You can't choose to advertise for a position and say, only this kind of people should apply, or these kind of people should not apply. This should be obvious, hopefully to you, that's illegal, and it's besides being illegal. I think the vast majority of Americans now have it in their value framework that these are also immoral to do this, whether they were illegal or not. All right, so let's get into some of the exceptions on protected class. So in order to comply, for example, with the Americans with Disabilities Act, if somebody tells their employer that they have a disability, the law basically states that the organization must make reasonable accommodations, and those are the words, reasonable accommodations. It's tough to define, all of the myriad of ways that might apply situationally. And that's, generally why we have a court system. We create laws, we try to be clear in the writing of the laws, and then we discover that words are difficult in terms of conveying every situation. And so then courts, in some cases over years, decades, and even centuries, sort of adjudicate, we argue as a society within our courts, what that situation and context is, and there has been some exceptions that have been established in the Americans with Disabilities Act that relate to what is a reasonable accommodation. So again, it comes down to words and what do we mean by words. But if a business can show that providing the accommodation would cause an undue burden to the business, that in some cases that reasonable accommodation isn't required, but the devil's in the details, and this thing is something that an organization can't just decide what is or isn't an undue burden. If there's case law, if there's precedent, they can feel more confident about it. If they're just deciding what they mean by a burden, they can run afoul of the law, and so that's kind of the risk as you interpret this as an organization, and that's why you have lawyers. And lawyers look at what the past court cases were, and if the courts have been clear in previous decisions that what you consider to be an undue burden to make an accommodation, if you are in a business that is hiring people that people must stand on their feet and must use all four limbs and must move around and lift a lot of weights, and the person cannot physically do that because of a physical disability, under certain conditions that can be deemed an undue burden to the business, because you can't, if you can't reasonably find an accommodation. Again, devil's in the details here, and businesses take risks in this area at their own peril, both from being fined by the federal government as well as potentially being sued. And so courts establish what those limits are on reasonable accommodations and what an undue burden is or is not. All right, so exceptions for compliance to the Civil Rights Act and the age discrimination laws. It could, which is to say that under certain circumstances, and this is what case law is for, and this is what the courts are for, to discriminate if there's what's called bona fide occupational qualifications, or BFQC. So what might that mean? So religious organizations, in some circumstances, can insist that who they hire be members of their religion, and that in some circumstances it's legal to not hire somebody because they aren't affiliated with your religion. It depends, but this is one area in which the courts have made an exception. Another area is some transport industries. You think of transport, you've got trucking and aircraft and trains and that sort of thing. Some of those industries it has been decided by the courts that a mandatory retirement age is acceptable. But these are two examples, and if you are an organization, you don't just get to decide these things. This is something that, as I mentioned before, gets decided by our legal system. And these rulings, when the courts come through to rule them, they tend to be very narrow, and exceptions are made only in rare circumstances. And thus far, and I can't imagine it would ever change. The race is not an acceptable bona fide occupational qualification. But in the two examples for religion and age, there are some narrow exceptions. All right, so let's get into a little bit of the legal theories of discrimination and some terms here. So disparate treatment. If an applicant, or that this is a hiring, this is a lecture about hiring, but it also applies to employees. If they're treated differently based upon their protected class status, that's considered disparate treatment. And so another way to look at disparate treatment is you're discriminating and you're doing it on purpose. You know that you're treating this person differently because of their protected class status. That is called disparate treatment. There's another thing called adverse impact. Now, adverse impact is unintentional discrimination. So you don't necessarily have somebody deliberately making decisions based upon your protected class, but you have unintentional actions happening that nonetheless create the same harm or create some other kind of harm that unduly affects people based upon their protected class status. And one way that you can look at your organization to see where to make sure you're not creating adverse impact is looking at things like hiring ratios. So, and there's this thing called the 80% rule. So if you are an organization and you hire lots of people, but consistently over time, when someone of a particular protected class is up for a position, and you're interviewing a bunch of people, and you look back at the data over time, and if every time you have somebody of a particular protected class go for a job, if they're less likely by 4/5 compared to the majority to have been hired in this case, or selected for whatever employment decision, if you remember, it's a lot more than just hiring, that is considered adverse impact. So it's called the 80% rule. So as an example, if you have if you have positions, they've been opened, you look at them over time and see that 37% of the applicants were women. That 35% of women applicants were selected, and 53% of male applicants were selected. You have a selection ratio. Remember that term, selection ratio. In this case, we're comparing the selection ratio of two different groups. And here we're looking at across the dimension of sex, and recall that sex is one of the protected classes. And in this case, you have a adverse impact in this case for women, because you are selecting men. So in this case, slightly over half of the applicants that are male that for your positions you're hiring, and only 37% of the female applicants for your positions you've hired, and that's looking back at your data, or it could be the federal government looking at your data under subpoena. And so that ratio then, 0.37 over 0.53, is 70%, and that's below the 80% rule. And so that could be deemed as adverse impact. You could be subjected to fines, federal fines, and you could be sued by, in this case, these would be public if you were found by the federal government to be in violation, and then some women that you did not hire would have a pretty strong legal case that you deprived them of a livelihood, and you could get sued. So these things are important things that human resources and legal departments and organizations take very seriously. All right, so that means that your selection methods, the tests that you use, you really need to make sure they're valid, and that if you see some creeping adverse impact, if you you're creeping towards that 80% line, you need to revisit this, revisit your selection method, your tests, your process, revisit their validity, and get your tests reestablished so that you don't have adverse impact. This is a real thing. Big, especially big corporations that have a lot of money and a lot on the line in the case of brand damage. If there was federal fines besides the dollar value, but then of course the liability from discrimination suits. So this is looked at very closely. All right, look at that. 25 minutes for the nuts and bolts of that lecture. So let's recap. So we went through hiring decisions and we talked about the employee selection process. We talked about selection. We talked about selection ratios, and we talked about cutoff scores, and then we talked about hiring and the law, and we talked about other employment decisions and the law as it pertains to protected classes, and then we talked about the legal exceptions, some of them, to protected class status, and we talked about the legal theories, and we talked about the 80% rule. All right, next lecture, which should also be a nice short lecture, might even be shorter because the chapter 5 is quite short, and the next lecture is about recruitment, and the portion of the chapter that talks about recruitment is pretty small. I've added some good material for you to know, but you'll probably find that the bulk of the questions for unit test 2 that relate to chapter 5, the bulk of them will come from lecture 13 that we just went through, and only a couple I suspect will come from lecture 14, and then of course lecture 15 on retention is a bonus lecture. So next lecture, for lecture 14, finding talent or recruitment, we'll talk about what does it mean to be the most qualified. We'll talk about the labor market. What does that mean? We'll talk about how you cast your nets, and how big you make your nets for recruiting. We'll talk about how you can leverage external partners to help you with recruiting. And then overall, what does an organization do when it wants to become the employer of choice? All right, that was nice and short. I'm making up some time for you. We'll see you next lecture.